So in last class, we have started with the concept called as agency. So agency is not defined under Indian Contract Act. The word agent and principal is defined. Agent is a person who is employed to represent another to enter into a contract on behalf of another. That person is called as agent. The person who so represents, the person who employed, that person is called as principal. So while we have discussed about the contract of agency, there is some essential elements for agency. What is the first essential element? For every act of agent, principal is liable. And for creation of agency, consideration is not required. Agent is always liable to the principal. Agent is always liable to the principal. Okay, sir. Right. Agent is always liable to the principal, and also, sir, the capacity of parties. Agent may be a minor also, agent may be unsound mind also, but principal always a competent party. These are the concepts we had discussed in the last class, and also we had discussed about the creation of agency. Creation of agency by express agreement completely, creation of agency by implied agreement, out of that implied by operation of law and by act of parties, agency by estoppel, agency by holding out, agency in case of emergency. These concepts were discussed in the last class. Today we are going to discuss about agency by ratification. We have discussed about the concept called as agency. So agency by ratification. So before that, what is my concept? What is meant by ratification? Sir, ratification का meaning क्या है sir? What is that? Sir, simple examples. Simple example. Listen. Suppose parent is there, mother is there, mother or father. And in that particular house, child is also there, child. You, your mother or your father. You is there and your mother and father is there. So your mother appointed you. Array, you went to the nearby shop, grocery shop, and you can purchase one liter oil packet. Like that, the mother 100 rupees are given to you, and he appointed you as agent. She appointed you as agent, and you went to the nearby grocery shop, and the child enter into a contract with the grocery shop on behalf of mother. He representing the mother. Okay, sir. Here, mother is called as a principal, child is called as agent. Then you went to the shop, you purchase oil packet cost is 90 rupees. Remaining 10 rupees are there. 10 rupees are there. With the 10 rupees, you purchase the chocolate. And you return to the home. The moment when you return to the home, your liability, what is your liability? Should return 10 rupees to the mother or not? That is your duty. You are an agent, you are appointed for purchase of oil packet, not for anything. That is the why I can means the principal give 100 rupees to you. Then you went to the market or you went to the grocery shop, you can purchase oil packet, but remaining amount, with that remaining amount, what you did, sir, for remaining amount, you purchase the chocolate. Generally, in this particular example, you are not having a right to purchase a chocolate. You are not my agent regarding to purchase of chocolate. Then you purchase the chocolate and you return to the home. The moment when you return to the home, mother asking for where is 10 rupees change. Then you said to the mother, Ma, I will purchase a chocolate with the 10 rupees. What mother will do, sir? There is a two situations. Either mother scold, yes fellow, waste fellow, why you are wasting the money? like that, or she accept what you did. So this is nothing but accepting what you are already perform an activity. Initially, you are not having such a power, you perform an activity. After that, principal accept such a transaction, the acceptance of past transaction. So accepting past performance or accepting past transaction is called as ratification. In this scenario, simple, so in case of principal and agent, generally principal is appointed an agent for doing one activity, but agent enter into a contract. Agent is not having that right to do such act, but agent perform an activity. Generally, agent is not having such power, but agent perform an activity. After that, principal accept it. After that, principal accepted is nothing but accepting past transaction, that is called as a ratification. What is that? So ratification means accepting past transaction. Simple set, simple scenario, simple example. Generally, what happened? Principal appoint an agent. On behalf of the principal direction, agent enter into a contract. This is the scenario. But agency by ratification, what happened? First of all, agent enter into a contract with the third party. Later on, principal appoints that agent. Normal scenario, sir, you are perform an activity as per principal directions. Principal appointed you, you are enter into a contract. But agency by ratification, first of all, agent perform an activity, later on principal accepted, later on principal appoints such person as an agent. So these type of situations is called as agency by ratification. This is called as agency by ratification. ये क्या है sir? One more example. Simple example. Listen. Sir, brothers, brother 1 and brother 2. Ram and Lakshman. Ram is there, Lakshman is there. Sir, Ram residing in Hyderabad, Lakshman residing in Bangalore. Bangalore. What happened? Ram, this person Ram also in Bangalore, he has a flat. He has a flat. Ram has a flat. And obviously, we are residing one city or having both properties in other cities also. Ram also has a flat in that particular Bangalore. What happened, sir? Ram brother Lakshman is residing in that particular Bangalore beside flat. Lakshman residing here is a Ram flat. Ram is residing in Hyderabad. Now no one is residing in that particular flat. Okay. What happened? One fine day, person X approaches. Why? Because approaches, sir, this flat is required for rent of 10 months. 10 months. Now flat is vacant. No, then Lakshman, what happened? He is enter into a contract with that particular X. Okay, no problem. The flat is available for rent for 10 months. Like that, the Lakshman enter into a contract. Lakshman enter into a contract with the person X. Okay. So in this example, what is my doubt? Here, Lakshman is appointed by Ram to enter into a contract with X. Or that is a Ram property. Who are you to enter into a contract on behalf of Ram? Just you are a brother, you are not appointed as an agent. You are not having an authority to give such a flat for a rent purpose. Normally, without informing to the principal, without knowledge of the principal, you are entering into a contract with the tenant, give a particular flat for rent of 10 months. After 1 week or after 10 days, what happened? You went to the Hyderabad for a family function. There's a family function, then as a first March or second March, you went to the Hyderabad. The moment when you went to the Hyderabad, whatever the money you received advance, 20,000 rupees you have received from X, that advance money given to the Ram, Annaya, what I did, one person approached to me for that particular rental purpose now vacant. No, I'm already entering into a contract with that particular party, obtain 20,000 rupees from that particular party. Please take this 20,000 rupees. Like that, Lakshman deliver the money 20,000 rupees to the Ram. Ram is accepted. Ram is accepted. Okay, Ram, no problem. Ram accept the 20,000 rupees. So listen. In this scenario, the moment when Lakshman enter into a contract with X, Lakshman is an agent of Ram. No, no, sir. He is not an agent. He is not having an authority to do such activity. He perform an activity. After performance, after agent enter into a contract, the principal Ram accepted. So this concept is called as accepting past transaction or not? Yes, accepting past transaction. This is called as ratification. Ratification का मतलब क्या है सर? Accepting past transaction. Accepting past transaction. Here already transaction is arises. Transaction is complete between brother 2 and X, Lakshman and X. Without knowing of brother 1, later on brother 1 is ratified, later on brother 1 is accepted, then this type of transaction is nothing but this type of concept is called as ratification. I hope that everyone is clear what is ratification. General scenario, what happened? Principal appoint an agent, agent do an activity as per principal directions. But in this ratification, what happened? First of all, agent perform an activity, later on principal accept, later on principal ratify the past transaction. This is called as ratification. But law clearly says that whenever you wanted to ratify, you should follow some rules. Rules for valid ratification. Rules for valid ratification. What are the rules for valid ratification? इसका मतलब क्या है sir? What are the rules for valid ratification? First of all, principal wanted to ratify the transaction. He is having full knowledge about transaction. He is having full knowledge. He know about everything. Yes, he is entering a contract to him. How much amount he can take and how many months he can give a rental basis. Like that, he know about full knowledge. Yes, sir, it can be treated as a valid ratification. Principal must have full knowledge of the facts. Full knowledge of facts. Principal must have the full knowledge of the facts. After know about all the facts, then only he ratify the transaction. And also, sir, you wanted to ratify, principal can ratify only lawful acts. See the rental tenant, it's a lawful activity or not? Yes. Suppose you supply the drugs, after that principle is accepted. No, it's can't like that. Whenever you wanted to ratify, ratification is always a lawful activity, a legal activity, wide activity, ultra virus activities. It's not permissible. You wanted to ratify ratification of lawful activity only. And also, sir, you wanted to ratify whole transaction, you can ratify, not a part transaction. Whole transaction can ratify. How, sir? Here in this example, here this party give a rent for 10 months. You wanted to ratify it, you can ratify entire tenant of 10 months. You said that I will ratify only 5 months. I cannot buy after 5 months. We wanted to shift to Bangalore. No, we will accept only 5 months. It is not possible. You wanted to ratify it, you can ratify full transaction, complete transaction, whole transaction only you can ratify. The part transaction you cannot ratify. And also, sir, ratification done by principal itself. So in this example, sir, brother Lakshman approached to the family function. He delivered the money to the Ram wife Sita. Sita accepted the 20,000 rupees. That is not yet treated as ratification. Why? Because ratification is done by principal itself, not by the any other party which is related, like that whole transaction can ratify, and ratification done by principal only. Ratification done by principal. And also, sir, because of your ratification, third party does not suffer any loss. Suffered loss. So third party does not incur any loss because of your ratification. ये क्या है, sir? What is this? Sir, one example. Ratification does not amount to a loss to the third party. What is that? Sir, listen. What is it? Sir, here landlord and tenant. Landlord enter into a contract of lease of that particular land for 2 years. So they are clearly mentioned in agreement. This is a lease agreement for 2 years. If any person wanted to withdraw, any person wanted to breach, they can breach, but 3 months prior notice is required. There is a 3 months prior notice. No problem. If you are not interested, I am not interested to continue within 2 years, then you can vacate. I can demand for vacation, but 3 months prior notice is required. Like that, they are entering into contracts. Okay. So in this scenario, meanwhile, landlord not interested towards a tenant, compulsory 3 months prior notice is required or not? Obviously, yes, 3 months prior notice is required. Yes, sir, 3 months prior notice is required. So what happened? One of the agent, landlord agent, he is not having such authority to give a 3 months notice. Landlord has an authority to give a notice. He is not having an authority, he is not appointed an agent for that particular lease agreement. But what happened? Without having authority, agent give a notice to the tenant. Agent give a notice to the tenant. Yes. After that, generally agent give a notice to the tenant. Agent communicate the notice. After that, landlord ratified. Ratification. Generally, what we are studied, sir, ratification accepting the past transaction. Generally, agent is not having an authority. Agent perform an activity, later on be ratified. But because of this ratification, tenant incurred loss or not? Tenant incurred loss or it's a loss to the tenant. That is the reason why what lawmakers clearly says that the principle wanted to ratify, the ratification is not injury to a third party, not a loss to the third party. Here in this example, you wanted to ratify it, the ratification is injury to a third party, loss to the third party. This is not a valid ratification. That is another condition, ratification, not a loss or not an injury to the third party. Okay, sir. And also ratification must be communicated. Communication. Obviously, can communicate it to principal can communicate it to the third party. These are all our rules for valid ratification. So principal wanted to ratify, you know all the facts related to that contract. and lawful act only he can ratify, whole transaction only he can ratify, principal only he can ratify, not his wife or any person. That is not injury to third person, and ratification must be communicated to the other party. If these conditions are satisfied, then only such a ratification is a valid ratification. Yes, this is the concept of creation of agency in three modes. One is by express agreement, another one is by implied agreement, another one is by ratification and the rules of valid ratification. I hope that everyone is clear. Everyone is clear, having any doubts in this concept? Now, now we wanted to discuss about the types of agents. Now we wanted to discuss about the concept called as types of agents. So generally, sir, who are the types of agents? So listen. So generally, agents are broadly classified into two categories. Two bases agents are classified. What is the first base? Based on work. Another base based on authority. Based on these two bases, agents are classified based on work and based on authority. So what is based on work? So based on work, agents are broadly classified into two categories. One is mercantile agent. Another one is non-mercantile agent. So इसका मीनिंग क्या है सर? सर mercantile. Sir, mercantile. What is the meaning of mercantile? Mercantile is nothing but business. So any agent is appointed for business activities, for mercantile transactions, for business purpose. Agent is appointed. That type of agent is called as mercantile agent. Non-mercantile agent means agent is appointed for other than business. For take care about your property, for take care about you, for take care about your people. Like that, the agent is appointed other than business. Such agent is called as non-mercantile agent. It's nothing but mercantile agent and non-mercantile agents. Best examples: lawyer is appointed. Suppose you have a case in the court of law, you appointed a lawyer. That is a business purpose, no service. Chartered account internal auditor is appointed. It's not a business purpose. The service, like that, those are called as non-mercantile agents. For business activity, any person is appointed. That person is called as mercantile. So sale of goods, consignment, auction sale, sale of goods, consignment, auction, these are all are mercantile business related activities. Those agents are called as mercantile agents. Non-mercantile means other than solicitors, chartered accountants, okay, sir, guardians, promoters of a company. These are all are non-mercantile agents. Okay, so this is the first category. Second category based on authority. So based on authority, agents are broadly classified into three categories. Based on authority, what are the three different types of agents? First one is special agent. Sir, who is special agent? Sir, name itself. Who is special agent, sir? The agent is appointed. Agent is appointed for special purpose. Agent is appointed for special purpose. Best example, sir, auctioneer. You know, in case of auction sale, auctioneer is appointed. So auction is appointed for only a particular purpose or not, for sale of auction sale of that particular product. The agent is appointed for a special purpose. That type of agent is called as special agent. The special agent is having limited authority. It's not having unlimited, only for a particular activity. He's having limited authority. Is a special agent. So next type of agent. So what is the next type of agent? There is nothing but general agent. Next type of agent, that is nothing but general agent. So who is a general agent? General agent. Who is general agents? So agent is appointed for ordinary course of business. So the agent who is appointed for ordinary course of business, just like a mercantile agent. So general agent means agent is appointed for ordinary course of business. That person is called as a general agent. Okay, sir. So special agent means only one activity. General agent means any series of business activities. Only business, sir, not about any other. Last one is universal agent. Sir, who is a universal agent? So universal agent means agent for unlimited authority. Unlimited authority. All the activities of principle. Every activity, business, personal, whatever it may be, for every activity of a principle can perform. That is nothing but universal agent. Universal agent authority is unlimited. But special agent and general agent authorities are limited. This is nothing but types of agents based on work and based on authority. Mercantile agent, business purpose. Non-mercantile agent, any. So mercantile agent examples, special agent and general agent. Non-mercantile agent example, universal agent also. Special agent for a special purpose. General agent, any ordinary course of business purpose. Universal agent for each and every activity. For these two agencies liability or authority is limited, but universal agent, agency authority is unlimited. This is the concept of types of agents in Indian Contract Act. Along with these types, there is a two more different types of agencies are there. Very important. Those are nothing but sub-agent and substituted agent. These are the different types of agencies. Out of these two different types of agencies, there are two more different agents are there. One is a sub-agent. One is sub-agent. Another one is a substituted agent. Sir, who is sub-agent and who is a substituted agent? Dhyan se suno. Listen carefully. So, principal appoints an agent. This is nothing but contract of agents. So, contract of agency is created between the principal and agent based on trust and confidence. So, I appointed you as my agent. How much confident I am? How much I am having that much confidence, that much trust on you. That is the reason why I appointed you as my agent. Then for the same work, you can appoint for the same work, you can appoint another agent. Whatever the work given to you can delegate the work to this particular person. Generally, what law clearly says that delegators protest non-delegate. इसका मीनिंग क्या है सर? So once anything is delegated to you, you are not having any power delegated to the other. Sir, I delegated some work to you, sir. You are not having any power to delegate same work to the any other person. Delegators, I am delegating or delegated protest, non-delegate. You are not having such a power to delegate it. Okay, sir. Like that, sir, principal appoints an agent, agent can appoint another agent. This agent is called as sub-agent. Generally, sub-agent is not possible. That is what law clearly says that delegators protest non-delegate. Once anything is delegated to you, you are not having a power to delegate the same work to the other party. Like the principal appoint an agent, agent cannot appoint another agent, agent cannot appoint sub-agent, sub-agent is not valid generally. Generally, it's not valid. But so agent wanted to appoint a sub-agent, agent wanted to delegate the work to the sub-agent. Before appointment, before appointment, what agent will do, sir? Listen. Right, sir. Right. Before appointment, what agent will do, sir? Agent should get a permission from principal. So agent gets a permission from principal and he appoint a sub-agent, then that is valid. That appointment is nothing but sub-agent is properly appointed. Sub-agent is properly appointed. So without permission, you are appointed. Without permission, you are appointed, then such sub-agent is called as improperly appointed. Sir, sub-agent is properly appointed, sub-agent is improperly appointed. So sub-agent is properly appointed means at the time of appointment of sub-agent, you should get the consent from principal. Improperly appointed means without consent of the principal, you appoint sub-agent. So sub-agent is properly appointed in this scenario, in this situation, whatever the activity done by a sub-agent, principal is responsible. Sub-agent is improperly appointed, whatever the activity done by a sub-agent, agent is responsible. Clear, sir? Sir, who is sub-agent? Who is sub-agent, sir? He is a sub-agent or not? This who is sub-agent? Sir, he is a sub-agent, sir. He is sub-agent. Sir, he is sub-agent. Sub-agent is an agent. Yes, sub-agent is an agent. Who is appointed by agent? Yes, who is appointed by agent? Who is responsible to agent? Obviously, sir. So, sub-agent is an agent who is appointed by an agent. Yes, principal is there. Principal appoint an agent, agent appoint a sub-agent. So sub-agent is an agent. He is appointed by an agent who is responsible to an agent. If sub-agent is properly appointed for every activity of sub-agent, principal is liable. Sub-agent is improperly appointed for every activity of sub-agent, agent is liable. Properly appointed means before appointment, you should get the permission, consent from principal. Improperly appointed means without consent of the principal, you appointed. Clear, sir? Everyone is clear? Sub-agent. Who is sub-agent? Sub-agent is an agent appointed by an agent who is responsible to an agent. If he is properly appointed for every activity of sub-agent, he is liable to the principal is liable. Is improperly appointed for every activity of sub-agent, agent is responsible. This is the concept of sub-agent. Clear, sir? This is the concept of sub-agent. Everyone is clear? Next, sir. Sir, who is a substituted agent? Substituted agent. Sir, who is substituted agent? Suppose principal appoints an agent. So agent is not having much a time, is not qualified to do such particular activity. Then what happened? Agent replaced. Agent replaced with another agent. First of all, agent is appointed, but he is not having that much capacity or not having that much time or not having that much qualification to do such work. Then agent replaces with another agent. Another agent. Such agent is called as substituted agent. Sir, substituted agent is agent who is appointed by an agent as per the service. Listen. Substituted agent is an agent who is appointed by the principal as per the directions of agent. Who replaces the agent, sir? Sir, here sub-agent concept of view, principal, agent and sub-agent. Sub-agent is an agent who is appointed by an agent, who is responsible to an agent. But substitute agent is not like that. Sub principal appoint an agent, agent is not capable, then he replaces with another agent. That agent is called as substituted agent. Substituted agent is an agent who is appointed by principal as per the directions of agent. So for you appoint an agent, but you are not having that much capacity or not having that much work, that much time to do the work. Then you recommended one person. Then based on your recommendation, principal is appointed such a person as a substituted agent. Clear as a substituted agent is an agent appointed by the principal as per the directions of agent. But here, sir, for every activity of substituted agent, who is liable, sir? Principal only liable. Obviously, for every activity of substituted agent, principal is liable. But in one condition is there, one exception is there. Sir, principal appointed substituted agent as per the recommendations of agent or not? Now, agent can recommend a qualified person, proper knowledgeable person. So, agent recommended qualified, proper knowledgeable person. If any loss arises, any damages arises, principal only responsible, principal is liable. But agent recommended unqualified, not having that much experience and expertise or knowledge, waste fellow, then he is recommended the waste fellow, then any loss arises, any damage arises, who is liable? Agent is liable. Generally, substituted agent is appointed by the principal itself, but principal is appointed not on his own knowledge. The recommendations of the agent, he appoint an agent. He recommendations are X means he recommended good recommendations. Then whatever the activity done by a substituted agent, principal is liable. But he is not recommended proper person. If the any loss arises because of such improper person, any loss can be borne by agent itself. These are the two different concepts, sub-agent and substituted agent. Who is sub-agent and who is substituted agent? Now we will discuss about the differences between sub-agent and substituted agent. Sub-agent, substituted agent. So first of all, definitions we know about who is sub-agent, who is substituted agent. Sub-agent is an agent appointed by an agent. He is responsible to an agent. Substituted as an agent who is appointed by the principal as per the directions of agent is liable to the principal. After that, who is responsible? So for every activity of sub-agent, if sub-agent is properly appointed, principal is liable. For every activity of sub-agent, if the sub-agent is improperly appointed, agent is liable. For substituted agent, sir, for every activity of substituted agent, who is liable? Principal is liable, but agent recommended improper person, if the any liability arises, agent is liable. There's nothing but responsible. Appointments. Who can appoint sub-agent? Agent can appoint sub-agent. Who can appoint substitute agent? Principal can appoint substituted agent. Clear as sub-agent and substituted agent, everyone is clear? Or any doubts related to this concept, sub-agent and substituted agent? Tell me, sir, any doubts related to that sub-agent and substituted agent? Who is sub-agent and who is substituted agent? Everyone is clear? Any doubts related to that? These are the different types of agencies. One is based on work, based on authority, mercantile agent, non-mercantile agent, special agent, general agent, universal agent, sub-agent, substituted agent. Clear, sir? Sub-agent and substituted agent. Everyone is clear? Or any doubts related to that? Clear? Everyone doubt on that? So sub-agent, it is at section 191. Substituted agent is nothing but section 194 and 195. Okay, so these are the differences between sub-agent and substituted agent. What is the definition? What is the section? Who appoints and who is responsible? Properly and improperly appointed, then proper person recommended, improper person recommended. What are the different scenarios? This is the concept related to the types of agencies. Everyone is clear? Having any doubts? Sir, everyone doubt on the clear? Tell me, sir. Everyone is clear? Any doubts? Clear? Next. Now we are discussed about the concept called as rights and duties of agent. Rights and duties. Before that, we will disclose in our material. In our material, what are the matters are there, right? Sub-agent is properly appointed. Sub-agent is improperly appointed. Properly appointed means with the consent of principal you are appointed. Improperly appointed means without consent of the principal you are appointed. So properly appointed, then agent is principal is liable. Principal is responsible. Improperly appointed, principal is not responsible. Substituted agent is an agent who is appointed by principal as per the directions of agent. Okay. Clear?